Once again, a very warm welcome to all of our attendees to this Tuesday morning Toolbox Talk. Once again, the invite from IOPSA to the Plumbing Industry Awards happening on the 28th of July, 2022. That is at the Royal Elephant Hotel and Conference Center. So for more information on that, please contact marketing@iopsa.org. Then we also have our tips to continually prevent COVID-19. We do realize it's something that is constantly spoken about. We also know that there have been the new regulations that have been sent out. Please remember, it is a legal requirement in order to have this poster up at your offices now. This is the requirement in terms of exposure to COVID-19 at a workplace, the responsibilities of employers and employees. If you want more information on that, you can either find the poster at LexisNexis or also through the SAOSH website. And I will be sending out an email to most of you who have already contacted me for this poster. And you can just buy it directly from LexisNexis themselves. We are not personally going to be having ones done with our logo on it, just because the expense is too much and we want you to get it directly from them as well. But we will have those regulations drafted out for you as soon as possible so that we can get you that information directly to you as soon as possible. So just to remind you about those tips to prevent COVID-19, that is washing your hands regularly for at least 20 seconds with soap and water. If that is not available, please use an alcohol-based hand sanitizer until you can wash your hands. Avoid touching your eyes, nose, and mouth with unwashed hands. Adhere to your social distancing and also avoid contact with people who are sick, which means if you are sick and you have taken a test and you are COVID positive, please refrain from associating with people. Many of us, even myself, I've gone through a bit of a flu stage, went and got tested and it's not COVID. So then it's okay. But then we are still encouraged to please continue with our normal hygiene practices. Cover your cough or sneeze with a flexed elbow or tissue and throw that into the bin. And then also clean and disinfect frequently touched objects and surfaces. So this morning's Toolbox Talk, or for the rest of this month, we are continuing with the working at heights fall protection topic that we have been discussing over the past month. So we've looked at ladders, we looked at ceilings, scaffolding, but we also want to look at fall protection as a basic fundamental requirement within any company. Now, we had fall protection Toolbox Talk not so long ago, and we discussed the requirements of Construction Regulation 10. We're not going to discuss that today. We want to look at fall protection just in a general requirement. In other words, whether you're in construction or not, we want to take a look at how you as an employer and employees can work together to form some sort of fall protection plan within your own company. We're then going to start looking at working at heights again in safe working procedures and safe operating procedures. And there we've got some templates that we can assist you with as well. And then we're going to move on to daily safe task instructions as well as your planned task observation, which makes up your risk management structure of the company. And then finally, at the end of the month, we'll actually look at the risk assessment itself. Again, we do have quite a few documents that we can send through to you in template format, ones where we've even made it site specific already for plumbers that we would like to share with other plumbers. And so what we've done, we've approached a few of our clients who are already plumbing contractors. And because they're quite big plumbing contractors, we asked them, is it possible that you have paid for certain services? Are we then able to take these services and make them freely available to other plumbers who might not be able to afford those costs? And they have said 100% yes, they would love for that to happen. So these are almost like sponsored documents where we have already made them site specific. So it's not just template format. And this will help you as plumbers then when you need to go and install a geyser, putting in, rotor tanks, things like that, doing water articulation, working at heights on ladders using different types of power tools, grinders and drills as well. So we've approached the clients and they have agreed to then give it to you plumbers as well. Now, whether you're a small company or a big company, it doesn't matter. If you need those documents, we want to assist you with it. But the safety thought that we want you to remember throughout this week, even though we're giving you these template documents or site-specific documents, paper doesn't save people. People save people. So it's by your actions and by your behavior that you will develop a safe profile for a company. So fall protection as such is a very important part of risk management, because as plumbers, you are going to come across a task that requires you to work at heights. As we've seen, working in a ceiling, having safe access on a ladder, working on top of a roof, working in a scaffold, or even working in a mobile elevated working platform, such as a scissors lift or a cherry picker. But why is it so important to ensure that you have prepared for and designed a plan to secure your working at heights tasks? Well, as you can see on the picture on the left-hand side, it's not the fall that kills you, it's the sudden stop at the end of it. The fall's impact on the body and the worker's collision with the point of impact are usually what causes a fall to become fatal. So incidents and accidents have occurred all the time with a fall. And this is as high as 300 meters, 200 meters, 100 meters, 50 meters. In fact, even as low as 1.5 meters, we have had falls that have been fatal. So fall, no matter what height, has a consequence of being fatal. The higher you go, obviously, the higher the risk, or the more likely it is that that fall will kill you. But even in suspension, having a harness attached to a lifeline, there is also the possibility of dying inside the actual harness from suspension trauma. And that's because it cuts off circulation to the body, and you will then start having your body shut down over a period of 10 to 15 minutes. So it's vital that all parts of our fall protection are looked at, not just before the fall, but even during and after a fall. Now, most people do not rely 100% on fall arrest. There are other methods to ensure that fall protection is put in place. So what works for you? What are you currently putting in place? What type of tasks are you performing that require fall protection? And again, we're not mentioning this because of construction regulations. Many plumbers think, well, we only need a fall protection plan according to construction regulation 10. And that's true. I've even mentioned the principles of fall protection, not construction fall protection plans, just basic fall protection, is still a legal requirement. So let's actually look at that legal requirement. This is what we call vicarious liability. As employers, we want to speak to you, managers, those who are representing your employer. You have a duty according to the OSH Act. In particular, we look at OSH Act Section 8, which is the duties of employers. And according to the OSH Act Section 8, specifically looking at subsection 2.d, it tells you that you have to have a risk assessment in place. You have to identify all the risks and make sure that you have mitigated them to a proper degree. In other words, you've done your due diligence in making it safe for your employees to work. Now, in doing so, if your employee does something that is dangerous or does not do something that is deemed to have been safe and it becomes a problem, who is liable for this? So this is always a question that is arising from employees and employers. Who is responsible when something goes wrong? Now, we never normally look at a person to be responsible because we want to find the solution to an actual problem. And 90% of the time, it's because there's some sort of system that is not in place, some sort of management system. Whether it be documented or not, there is a big gap in what is meant to be done in a company and how it is then executed. Yes, people are involved in that, but there's a lot more involved. There's some sort of system or process that should be put in place first and then taught to an individual, and then that individual can execute it in the correct manner. So we don't always only look at the person, but the law at Section 37 of the OSH Act states that people will be responsible and held liable should they do something or not do something. Now, most employers are unaware that they can be held liable for the actions of their employees. It's what we call vicarious liability, where you are held responsible for the acts or omissions of another person. And here we are looking at two people or two categories of persons that you could be held liable for. The first one is an employee, so somebody that you have employed to perform services for you. The other one is a mandatory, or someone like a service provider or contractor that you are paying on your behalf to perform work for you. So in other words, if you had to get an electrician into your office and you paid them for their services, if you didn't have some sort of safety negotiation between the two of you, you could be held liable if they did something wrong on your site. This vicarious liability also comes out in Neertling's law of delect. So he describes liability as the strict liability of one person for the delect of another. In other words, you then become wholly liable for the act or omission of another person. So vicarious liability is basically you are liable even though you are not at fault. Now, how does this actually work? Why is this a law in South Africa that you as an employer are held responsible for the acts and omissions of your employees? Well, let's take a look at the actual section of legislation. Section 37 says whenever an employee does or omits to do any act in which it would be an offense in terms of this act, then the employer or such employee or user needs to ensure that they can prove certain things. Now, for one, as an employer, you want to prove that you've done everything in your power to stop that from happening. But how do you do that? Well, number one, if you can prove that the employer or employee rather, doing so either omitted to do the act or was acting without the connivance or permission of the employer. Now, that's the first part. It's not this or that. It's this and that. So this is the first part. You must prove that they were doing it without your permission. Secondly, it was not part or any condition of the circumstance within their scope of authority. In other words, they were not allowed to perform that specific task without taking the proper measurements of safety. Now, this means that you should have written down in some sort of contract, normally an employee contract or an employment contract, what their scope of authority is. In other words, you've given them specific duties and responsibilities to carry out. This is not a verbal contract. This is a written document where every employee knows and understands what their scope of work is or scope of authority in the company is. Now, this is whether it is lawful or unlawful. So in other words, whether they were doing something that was according to the law or whether they're doing something against the law. If they didn't have the scope of authority to do it, then it could also be described as wrong. Now, what could be lawful that you do? In other words, it's the right thing to do, but you could be held responsible. Imagine you worked on someone, not worked on someone, but assisted someone that got injured in first aid, but you are not a qualified first aider. Well, that means that your scope of authority was not as a first aider, and you went over and above the law. So yes, it was right. You wanted to help someone, but that is not the right thing to do because it is without your scope of authority. So that is why it's so important for us to know and understand what are we allowed to do and what are we not allowed to do. So the third thing and final thing that must be proved over and above these two. So first of all, you acted without the permission. Secondly, you acted without your scope of authority. And third, you need to prove this. All reasonable steps were taken by the employer or any user to prevent such act or omission of that kind in question. Now, notice the highlighted point at the end of this piece of legislation. The fact that he, meaning the employer, issued instructions forbidding any act or omission of the kind in question shall not in itself be accepted as sufficient proof that he, the employer, took all reasonable steps to prevent the act or omission. In other words, if you were working at heights and you fell, the question is going to arise whether you did it without the permission of your employee or your employer rather, which is not normally the case. Normally your employer sent you to perform work. It was without your scope of authority. So you weren't allowed to be up on that ladder performing that work. Again, often not the case. So the third thing, very difficult. Were reasonable steps taken to prevent that person from working in a elevated working position unsafely? So this is where it comes down to. Now, employers, owners of businesses, CEOs, managing directors, I'm speaking to you. The fact that you issued instructions forbidding any act or omission will not in itself be accepted as sufficient proof that you took all reasonable steps. Now, what are reasonable steps? The law gives us clear guidelines as to what is reasonable when it comes to any type of safety behavior, because you will still be held liable for acts or omissions of your employees. So how do you go about ensuring that you have given verbal instruction, written instruction, as well as prove that you've taken all reasonable steps to prevent incidents and accidents from occurring? Well, there are 4 things that you must do. And it's basically the meaning of reasonably practicable, which is what the law speaks about all the time. What is reasonable and what is practical in order to make a site safe or the environment safe for your employees. So let's look at each one of these and then discuss why it is important for you to have this when it comes to our fall protection. Number 1, it's having regard or meaning reasonably practical, regard to the severity and scope of the hazard or risk concerned. So is the risk severe, and what is the scope of the actual hazard? In other words, if you have not done a risk assessment on that particular task, you will not be able to determine what the severity of the risk is or what the scope of the hazard and risk is either. Now, if you haven't done that, you have then not put in reasonable steps, because you haven't outlined the very first basic fundamental of what is reasonable: identifying what could harm the individual, assessing how the individual could be harmed and what are the consequences and likelihood of being harmed. In other words, the severity of the consequence, and then putting in practical measures to protect a person based on a risk assessment. The second thing is taking into consideration the state of knowledge reasonably available. So we're not asking you to go and do a university degree in research. We are saying reasonably, if you had to ask your health and safety practitioner, ask your institute, ask SIOSH, which is the Institute of Occupational Health and Safety, would you have reasonably available information concerning that specific hazard or risk, or even what is the means, the methodology of removing or mitigating, making that risk safer? So what is that state of knowledge? Is that knowledge reasonably available? Is it there for you to be able to have the knowledge in order to understand what the hazard is, what is the risk, what is the consequence, and how can we safeguard ourselves? Well, again, this is based on what is reasonably available. The third thing is then the reasonable availability and suitability of the means to remove or mitigate that hazard. Again, this is based on what is currently happening in the industry. And so we take what we call the reasonable man test. Now, in any piece of legislation, they will say, what is the law that is 100% what you must do? And then in order to abide by the law, we say that the person abiding by the law is a reasonable person. And that reasonable person will take certain steps in order to carry out that piece of legislation. So yes, we're snowflakes in our company. Everyone is different. Our personalities are different. The way we will approach things are going to be different. But they say based on a standard or what is generally accepted, that would then be considered reasonable. So it is vitally important that you as plumbers speak to each other about health and safety. When you have plumbers' evenings, when you have toolbox talks, when you have sites that you meet other plumbers, we understand that maybe you are, two separate individual plumbing companies and you're bidding on the same work. And so, yes, there might be competition in the environment or in the industry, but that doesn't mean that you cannot help to safeguard each other's lives or employees' lives. So if you are owners of the business and you have competition with someone else, can you put that aside to help another company on the health and safety side? We're not talking about business. Fine, that's a separate incident. But we're talking about people falling from heights. If you have found something that is effective for you, something that is cost effective, can you not share that with other plumbers? In fact, if you don't want to share it, you have got open communication with our OPSA and myself at OHSS. Send me the information and we will put it into a Toolbox Talk. And we've said this all the time. You can be anonymous in donating any information, and we will vet that information and see if it is adequate. Then the fourth thing is the cost, so the budget of removing or mitigating that hazard or risk in relation to the benefits. In other words, they say, weigh it up. What is the cost? And then what is the benefit? And if the benefits outweigh the cost, well, then that budget should be immediately in place. If the cost outweighs the benefit, it doesn't necessarily mean that we stop it altogether. We need to try and find a way of including that, perhaps over a series of work. So each of these have their own merits. Number one, you need to identify the severity and scope of the hazard. So Section 8 of the OSH Act, as we mentioned earlier, says that employers must, legally, you are required to perform a risk assessment of the works to be done by your employees. Scope-specific and site-specific risk assessments. This risk assessment will then outline what the hazards are and the risks that are going to be foreseen. Based on that, the risk assessor and risk assessment team will come up with a safe working procedure, what to do in order to protect yourself. Now, this whole safe working procedure must be outlined by the hierarchy of control. So these mitigating factors or making something safer must be based off of the hierarchy of control. That is elimination, substitution, isolation, engineering, then administrative, and then lastly, PPE. So the risk assessment will then determine, number one, the severity and the scope, and then help you to establish the control measures. Now, competency must be a part of your risk assessment. Who's doing your risk assessment? Who's on your risk assessment team? And do the employees actually know what is going in the risk assessment for working at heights? The second one is your state of knowledge reasonably available concerning the hazard of working at heights. Well, heights is a well-known hazard. It has a lot of knowledge-based information available. There is also a lot of information readily available for the protection of persons working in elevated positions. So we cannot say that it's not reasonable to expect knowledge to be available, because there are four means of fall protection. You can take a look at your risk assessment and see which one of the four means of fall protection will adequately safeguard you. So the question is, have you done your research on it? Do you know what is required, and do you know what is the best method for protecting yourself when working in a fall? Then the availability and suitability of the means to remove or eliminate that risk or hazard. So within each fall protection method, there are various means to apply proper fall protection. In other words, just because there are four, it doesn't mean there are only four means to protect. Within those four areas, there are various other means in order to apply to your specific scope of work. What does it require from you? You need to actively identify and plan for adequate and suitable means of protecting your employees when working at heights. There is no one-size-fits-all approach to fall protection. That being said, though, if you are able to share with us what's working for you, it might not fit every other person, but you could help one person. And we understand that helping someone, is not going to change the world, but hey, it might change the world for one person. So if you have that information available, share it with us. Let us see if we can assist someone else. Then the last thing is weighing up that cost. Now, with anything, any risk-based methodology or risk-based application, whether it's budgets, finances, business, everything comes down to weighing up the cost of risk. Now, when it comes to working at heights, we understand that the cost of life is there, but it means that you must have a budget for health and safety. We cannot work in businesses where we have budgets for everything else except for health and safety. This means you need to sit down and look financially at what your budget is for health and safety, not just minimum, but it requires that you weigh up what the potential risk is compared to what you have budgeted for. So what is the cost in relation to the benefits that you have derived? It also may mean that you might purchase something or put in some sort of safety mechanism that will not be covered by the profits of the first job. It may mean that you extend this past the first job to other similar jobs where you're going to use this on because you foresee that you're using it very often. And then slowly you can bite off each piece of this elephant to eventually pay it off. Again, each person, each company is going to handle this in a different way. The way you handle it might not be the same as someone else. Again, if you have a solution, let us know what you are putting in as a solution. And maybe we can assist another plumber to have a proper fall protection put in place, a proper fall protection plan in order to safeguard their employees. That's difficult. We understand that. To determine what is fair when dealing with what we call the cost of life. What is the cost of a human life? But that is why preparation is so important. We're not saying to you that the benefits is saving a human life, which is millions compared to what your budget is. We are asking you to be reasonable and practical. So go ahead, take a look at these 4 areas of being reasonable and practical. Safeguard your employees when working at heights. And if there is any way that we can assist you with information, with planning, we want to do that. Now, next week, as we mentioned, we are going to have some sort of templates available for you. If you want them now, before we even do the Toolbox Talk, reach out. Our email address is there on the left-hand side, info@ohss.co.za. Even if you send an email to safety@opsa.org, you will still get those templates because we are connecting with each other every single day. And then if you have any other advice for us, something that we want to remind you of, paper doesn't save people, people save people. So if there's something that you can do for another person, please do it. Thank you very much for joining our Toolbox Talk this morning. I look forward to seeing you next week on our next Toolbox Talk, as well as at the Plumbers Evening at the end of July, as well as the Plumbing in Darba that is happening pretty soon. And then we'll go ahead and hand it over back to you, Karim.
Thank you very much, Chris, for this informative session. I believe there are no questions from my side. Is there anything you'd like to add before I end off?
Just a very big thank you to all of the attendees, as well as those who have registered for Prime. We do understand that the first part of Prime was reading all the OSH Act and legislation, so it might have been a bit boring, but we are starting to get into a lot more meatier products, looking at risk assessment, higher incident, accidents, and emergency coming up in the next few months. But thank you very much for those who have already participated in Prime. We look forward to mentoring you throughout the next year. Thanks.